In this section, we would be focusing on the development aspects of the relation between human rights and the globalization. That is, that the kind of the development that takes place across the borders and its implications to the human rights, particularly in the context of globalization. As we discussed in the previous sections, the process of globalization facilitated the movement of the capital and various other economic activities across the borders. So, one of the important dimensions of this economic activity taking place across the borders is the movement of the capital in the form of investments. That is, that the foreign investors going from one part of the world to the other part of the world. Now, in the relation between, or in this economic activity of investors going to different parts of the world and investing it, how does that interact with the framework of human rights? At several junctures, this kind of relation comes out openly, that is, the relationship between the investor or the international law or the law dealing with investment and its interaction or its impact with human rights. One of the important aspects of the rights framework and its interaction with investment can take place in relation to what constitutes as part of the investment treaty regimes which have certain implications to human rights. For example, one of the important aspects of this interaction is that there is a possibility that some of the components of the investment treaty framework would have certain implications to human rights understanding. For example, direct and indirect expropriation that takes place in the host country, it does have implications of human rights in both ways, that is, in terms of the direct and indirect expropriation taking place in the name of human rights, and in this direct and indirect expropriation affecting the rights of the investor also. So, that means that the rights framework can operate in both ways, that is, that it might affect the rights of the investor as the right to property of an individual, it might also affect the rights of the or it is a consequence of certain measures taken by the state, because this particular investment activity might be affecting the rights of the individuals in the host countries. So, this is one aspect where you come across the rights getting interacted. The other form of interaction that can happen between investment and human rights is that there is a possibility that investors, that is, foreign investors, are expected to respect the human rights obligations that might emanate from the domestic laws of the host countries. The other form of human rights obligation could be that the home state of the investor might put certain human rights obligations on the investors as a kind of an extraterritorial application of a human rights framework. So, it can be that investors' human rights obligations in relation to the domestic law of the host state, or it could be the human rights obligations of the investors in relation to the home state obligations which might operate in certain circumstances in the form of extraterritorial application of a human rights framework. So, this is another framework where you come across the interaction between human rights and the investment framework. As an extension to this investment framework is the question of how that investment operates wherever it gets invested. For example, when an investment takes place or investment is facilitated by the host country, this investment might require certain amounts of certain economic activities which might impact the people over there. This could be mostly happens in the form of land acquisition that takes place, especially for some of the important examples that one can come across is in the context of India. The concept of land acquisition, which is primarily acquired for the purpose of facilitating the investment and other development projects, takes place by way of acquiring land from the individuals. So, this acquisition of land for the purpose of development is premised on the understanding of the concept of eminent domain. Land acquisition takes place for the purpose of the development projects under the framework of eminent domain. The concept of eminent domain as developed by Dutch jurist Hugo Grotius, which basically talks about the rights of the state to acquire the property from the private individuals without going through the process of market transactions. So, it gives a right to the state to acquire property from the private individuals for the purpose of public good, for the purpose of public welfare. So, this provides the possibility of acquiring land for the development projects, but what is happening is that for the in the name of acquiring land for the purpose of the development for the public good, the same land is being given to the private investors, which also can be arguably seen as development for the purpose of the public good. So, this here the acquisition of land, the process of acquisition of land directly contravenes the rights of the private individuals, right to own property, or in certain circumstances those who do not own the property, but that their subsistence is dependent on the resources from the particular land and the property. So, this is another uneasy relationship that takes place between economic activity that is predominantly taking place across the borders through the process of globalization and its impact on human rights. When this process of facilitating the investment and economic activities across the borders is taking place, at a conceptual level, it fundamentally going to the roots of the idea of rights and human rights framework. As I said in the beginning of the lecture, for the purpose of understanding of human rights, states play a significant role or a central role in the protection of the rights of the individuals. But in the last couple of decades, there is an argument that because of the process of globalization and because of the movement of the capital and the economic activities across the borders, it is not the states, but it is the private actors which are predominantly violating the rights of individuals. Therefore, there is an argument that the private individuals or non-state actors which are independent of a state should have certain human rights obligations. So, therefore, there is at the international level also in the lawmaking an argument is made that there has to be a legal mechanism to make the non-state actors comply with their human rights obligations. Now, this poses a conceptual problem in the sense that the general framework of human rights and the rights understanding developed over a period of time, especially in the legal and institutional framework, making the state as a central to this understanding. But once we shift this focus from the state to the non-state actors, how this rights framework work needs to be in a way reconceptualized as part of the legal framework. Towards this, that is that to make the non-state actors, especially the corporate and business entities, accountable to the human rights framework, there has been an argument at the international level to come up with an international treaty. So, as a kind of a preliminary step towards coming up with a legally binding international treaty, UN guiding principles on business and human rights were adopted by the United Nations Human Rights Council in 2011. The primary purpose of these UN guiding principles on business and human rights is to make the non-state actors, that is business group or corporate entities, accountable to human rights violations. So, this business and human rights guiding principles as adopted by the Human Rights Council in 2011 is based on three important pillars. The first pillar is protection of human rights, the second pillar is the respect for human rights, and the third pillar is the access to remedy if in the event of violation of these human rights. The first pillar of the protecting human rights lies primarily with the state. So, the guiding principle emphasizes that the primary responsibility of protecting human rights lies with the state mechanism. So, the first pillar with regard to the protection is with regard to the protection by the state of the human rights. The second pillar is with regard to the respect for human rights. The guiding principle emphasizes that there is an obligation for corporate entities and business entities to respect the human rights of those individuals wherever their operations take place. So, it means that they have an obligation to respect the rights of the individuals. Any business or corporate activity that they undertake should not violate the rights of the individuals in that particular circumstances. The third pillar is with regard to the access to justice, which means that in the event of failure to respect the rights, or in the event of the violation of the rights of the individuals, there has to be an access to remedy to those rights violations. That means that there has the institutional mechanism should be established, or the legal and institutional mechanism should be kept in place for the purpose of providing access to justice in the event of human rights obligations. This is one aspect of the non-state actors getting involved in the violation of human rights or in remedying the violation of human rights. This is one dimension of non-state actors' involvement in relation to human rights. The other important aspect, which is closely related to, but maybe it happens mostly in a conflict situation, is that violation of human rights by non-state armed groups. Now, this framework mostly covered or primarily covered by the international humanitarian law framework, where certain obligations do lie on non-state actors, though they cannot make this international law, or they cannot become party to international treaties, that is non-state actors. But the international humanitarian law framework talks about the obligations of parties to an armed conflict. Wherever the non-state armed group is a party to an armed conflict, it is expected that to respect those obligations which are part of international which are part of international law. So, therefore, the traditional understanding of the state-centric framework of human rights is also in certain respect undergoing certain changes with regard to making non-state entities obligatory to the violations of human rights. So, there is also an effort now to conclude a legally binding international treaty, especially with regard to the business and human rights or corporate entities and the human rights framework. It is expected that the binding international treaty should impose certain obligations on non-state actors, that is business and corporate entities, to respect the rights of the individuals wherever they undertake their investment and business activity. Why human rights have taken this dimension is an important dimension of this is this process of globalization, through which the economic and investment activities are taking place across the borders. Therefore, there is an emphasis by those who argue for human rights respect, emphasize that equally the non-state actors should be made accountable for their violations of the human rights.